that's just an amazing thing to actually print this out and show people what's actually in here. And then even better is there's a lot more of these things called rights inside this book here. And this is one that directly applies to all of us as well. But
Terry Kimmel wrote that one.
yeah. Well, that's an excellent idea because, frankly, a lot of people don't realize is that every state was required to put together, when they came into the Union, a Bill of Rights. And that Bill of Rights had to be greater than the Bill of Rights that was in here, otherwise they would not be admitted as a state. I don't know if everybody realizes that or not, but that is one of the requirements to become a member of, to become a state, was the fact that your rights had to exceed the rights that were in the Constitution of the United States. But I'm before such a learned group, I got a question for you. How many of you ever heard this statement? Extremism in the defense of liberty is no vice. Moderation in the pursuit of justice is no virtue. Does anybody know who said that? It was a guy that is now since deceased, but he was the presidential candidate in 1964. His name was Barry Goldwater. And he said that when he accepted his nomination speech in, of all places, San Francisco, California. Imagine that. Imagine having a Republican convention in San Francisco. And what was interesting was, after he made that speech, the left, the Democrats, you could say, they met him, when that speech was over, he was, of course, called a racist, because that's always a good thing to call somebody when you disagree with them. And they had demonstrations outside the Cow Palace when that took place. You go and read about it on Wikipedia or any other sources. It's kind of interesting because it's the same playbook back in '64, and you think about it, how many years ago is that? I mean, that's a long time ago. And here it is, the same playbook 60 years later. And those words, though, are true. Think about it. Extremism in the defense of liberty is no vice, and moderation in the pursuit of justice is definitely no virtue. And I got involved with Larry because he came to me, because I have a background in the legal profession. Fortunately, not as an attorney, because both my parents were married. And but I have had numerous experiences with the court system here, and I've also had them from the state I came from, which is California, and still to this day, I still do work for an attorney out in California right now on pleadings and other things. So Larry came to me with this issue that he was looking at in Eddy County, which is obviously the next county up. And it was about windmills, okay, wind turbines. And I got to be frank with you, I don't really have a pro or an adversarial view of them. I think they're kind of stupid when you live in a state that has so many natural resources that are so abundant and so cheap and so available. And what you want to do is you want to import a bunch of wind turbines from China. Makes no sense whatsoever. So, but I wasn't really interested in that question. What I was interested in was the procedure upon which these wind turbines were being thrust upon these people in Eddy County. And it appeared that the process was flawed and it was corrupted. And what they did was they were pushing these wind turbines through this rezoning, because they had to rezone things to have these wind turbines accepted, or to be lawful. And it was interesting because I would look at how they did this process with the rezoning, and the meetings didn't allow people to speak, because what they did, these idiotic members of the state's attorney and the planning and zoning and the commission, what they did, there's a statute in the North Dakota Century Code that says that at every meeting, at every single meeting of any body, any governmental body other than the state legislature, every time there's a meeting, you have to allow the public to come forth and speak. The unfortunate thing is that when the legislature wrote it up, they wrote that they said any regular meeting. Okay, so what happened is every time they wanted to jam this thing down the throats of the taxpayers up there, of the citizens, what they did was they called every meeting a special meeting. And I guarantee you, when the legislature put that statute together, what they were referring to when they said every regular meeting, they meant a non-executive meeting. Every meeting that was open to the public, whether they wanted to nominate it as a special meeting or a super special meeting. It didn't matter. All meetings were supposed to be open to the public so all people could comment on what was occurring there. So I could see from right off the get-go that what they were doing is they were playing with the statute. Because Larry, excuse me, had evidence that these very same zoning board members and very same commissioners had conflicts of interest because they wanted to pass this zoning so that these windmills could be placed upon the property that they apparently bought for that purpose. And when Larry had these deeds that showed, and these agreements that these officials had with this wind energy company, he could never get it into the minutes because of the fact that what they did was they never allowed for public comment, and by not allowing for public comment, he couldn't lodge the evidence of the corruption and of the obvious conflict of interest. And so what happened is we could see that, and what I did was we got together and we collaborated and we put together a complaint. Well, they said that you cannot complain about anything apparently when rezoning is going on. When rezoning is going on, then I guess you lose your right to speak before a body. I guess you lose your right to petition for redress of grievance over obvious conflicts of interest. And the only thing you're left with is an appeal of the rezoning. Well, how do you appeal something when the record is incomplete? It doesn't reflect what really occurred there. And that is going through the courts right now. We lost on our complaint, but we're working right now on an appeal, and I guarantee you our appeal before the North Dakota Supreme Court will most likely be successful. At the same time that took place, something even more interesting happened involving the state's attorney. The state's attorney, when confronted with these obvious conflicts of interest, she failed and she refused to do anything to prosecute these conflicts of interest. So it's little known in the Century Code. You can't really go after a state's attorney over things that you don't like that they do. Okay, you cannot sue them. You could say over issues about how they did something. You can only sue them over issues that they didn't do. And so we currently have a case pending against the state's attorney. Or Larry has a case pending because I'm not a resident, obviously, of Eddy County, against Ashley Lees. And it was interesting because the case against Miss Lees, her incompetence and her refusal to prosecute obvious corruption is documented. It's absolutely documented. And you can look at that paperwork if you're interested, because the case is on file up there in Eddy County. It's Dan Dern versus Lees. And you could read all about the state's attorney. And what's interesting is once that case was filed, then just to show you how corrupt sometimes the the legal profession can be. Somebody brought forth and gave Larry a copy of a bar complaint that turned into a stipulated judgment. A stipulated judgment means that, say, you and I have a conflict, and then what we do is we stipulate as to what the facts are. We both agree to them, and then that becomes what we call a judgment. Well, what had happened was this state's attorney, who apparently she had a case that she filed as not as the state's attorney, but in her own private practice. She had a case that she filed on behalf of somebody in an estate that had already been a stipulated judgment, where the case was already settled. What she did was she filed another action on behalf of this alleged aggrieved party, where the case it'd be analogous to, let's say that you were prosecuted for a crime, and then what happened is the state's attorney decided, well, I'm going to prosecute you again. Well, everybody in this room knows there's this thing called double jeopardy. Well, that applies to civil cases as well as criminal ones. Once a case has been adjudicated, you cannot bring the case again. You can appeal it, but you cannot bring it again. And that's exactly what she did. And what was interesting is we found out that this state's attorney, when she was brought before the bar, because the people that were the victim of her incompetence or her corruption or whatever you want to call it, what they did was they brought a case against her in the state bar. And when they brought this case against her, what did she do as an excuse for obviously her corrupt practices? She claimed that she was mentally incompetent at the time. And she wrote it out and put it in her stipulated judgment. She actually said, well, I was suffering from mental issues at the time. I was mentally ill at the time, and that's the reason why I did that. How can you have a state's attorney that's mentally ill? And she didn't mention whether or not she got any help, and she's no longer mentally ill. So for all we know, she's still there. And what was interesting is when Larry brought that into his pleadings to show that before the court, well, obviously as a county employee, she gets a law firm to represent her. She doesn't, of course, she's not competent, obviously, enough to represent herself. So she gets a 6-person law firm. If you go online and you look up Dan Duren versus Lees, you'll see it's Larry Dan Duren versus 6 attorneys. Okay? And it was interesting is, I thought it was funny because when they were, one of the opposition papers that they put together against some of what Larry had produced, is they said it was reprehensible what Larry did by including the state bar. This is an official document from the state bar that she signed saying that she was mentally ill. That was reprehensible. I think it's reprehensible that you have a state's attorney representing the people of Eddy County that is mentally ill. How in the hell is she going to, if something ever really happened, there was a real crime up there, and somebody that actually committed a real crime. Fortunately, nothing's happened like that I know of. But as an example, how would she possibly prosecute somebody that has a mental illness? You have a question?
That's exactly what I was going to say. How in the world could she prosecute anybody that would use the claim that they were mentally ill if she was mentally ill? And then maybe the judge is mentally ill. Where do you end up?
Well, it is interesting.
It's hard to believe.
So when you see this go on, you can't help but get involved. And like I say, frankly speaking, I don't particularly like windmills. I think they're stupid. Just the same as I think solar panels are stupid as well. And particularly when you have so many alternatives that are so much cheaper. The part that got me was the corruption and the issues along those lines. So what I was going to suggest is this is really interesting because this is the first step here, is knowing how this thing works, the Constitution of North Dakota, and the Century Code. And I'm developing a website right now that my intent is to help people self-represent themselves. And the reason why is because you just might end up with oh, by the way, that information that I was telling you about with the state's attorney and her being mentally ill and so on and so forth, well, the state bar made sure that that was never available to anybody else to see. They keep, if you try to do a public records request for state bar disciplinary actions, you'll find out it's very, very difficult to get any information from them because they protect their own. It's like it's their own little deal. So it's real important that everybody that wants to protect your rights, everybody that wants to be able to have open government, we have to be able to look at open records. And these counties and these cities and these agencies, they do their best to hide it, you know. And frankly, the only way I've found to get open records, and I've sued numerous people for numerous agencies for open records. I've sued the city of Carrington and won. I sued the county of Foster and won on open records. And it's not as difficult as you might think. But the thing is that going through any other process, because unfortunately Wayne Stingham, when he was in office, he was an advocate for open records, okay? I don't think this new guy is an advocate for open records. He's done nothing. He doesn't seem to be somebody that's really interested in constitutional rights. And by the way, open records are a constitutional right. They are a First Amendment right, because how can you be informed to speak on anything if you don't know what the government knows? And the only way you can do that is by having open records. And everybody should know you have a right to every single record that is in every agency. I don't care if it's the water board all the way to the state capitol. You have a right to get all those records. And it's very important to do that, because without that, how can you address, or how can you get redress of your grievances? How do you even know what's going on in the government? And I'll give you an example of that. It was really funny. I had a friend of mine that said, I want you to go, Ted, you don't really realize how our economic development people are doing, and what great job they're doing for our city. This is for Carrington. So they invited me to this meeting that they had for their economic development. And we have an economic development director in our town, just like they usually do in every community. I would say they're people that probably couldn't get a job most other places, and they have limited capabilities. But it was really funny because she knew that I was kind of this person that was holding the meeting, that was the economic developer, and this is about 5 years ago. And everybody remember Shopko's? They used to be around, right? Well, where Dollar General sits right now in this town is where our Shopko used to be. And that Shopko was just in the process of closing down. And so I said, well, I'll go to the meeting. And so I went to the meeting, and she saw me there. So she started spouting off all this stuff about, well, you know, I've gotten a hold of J.C. Penney's, and I'm saying J.C. Penney's, you know, they closed everything. They're closed out of Jamestown. They're gone. And I'm thinking to myself, but I didn't want to make an issue at the meeting. Oh, I got J.C. Penney's, I got this, I got that. And she named off all this crap that she said that she did. So when I left the meeting, I said, well, I think I'll just go to City Hall over there, and I'll go to the auditor's office, because that's under the auditor's office, and I'll say, I came in there and I wrote out, you don't even have to write them out, you can just tell them verbally. But I wrote it out because I want to make sure that they got it correct. And I wrote, I want all correspondence from this person to this person from this person. And what I found out was she didn't do any of those things. In fact, actually, what was funny was there was a few people that wanted to bring a restaurant to Carrington, and she did everything she could to make sure they didn't get here, because she was friends with the guy that owned this place at the time. So what she would do is she would refer them to Frank Klein, that was the owner of the Chieftain at the time. And so what I did was I took that information and I brought it to the next city council meeting, and I took her emails and I distributed amongst the council members. And now her husband happened to be one of the council members, and he didn't particularly like that. And he got through saying that he said his wife was sitting there as well at the council meeting, because she's an important official and all. And he goes, "You don't have to take this S from anybody." So what happened was the next week she quit. So I don't know, was that good? Was that worthwhile? And see, you could have never done that without that information. And I had to sue to get that information. Because what they did was, first they delayed, and they delayed me by weeks and weeks and weeks. Then the second thing they did, because I asked for the information to be given to me in a PDF format, in an electronic form, not in papers. I don't want to pay 50 cents a page for a bunch of crap. But what they did was they did exactly what I did not ask for. They delayed for like 2 or 3 weeks. They finally gave it to me, and they said, "Oh yeah, here's a bill for $300 and some odd for this paper, okay, for the stack of paper that was that big." Because what they did was they wanted to really punish me, so they threw a lot of duplicates. So they'd have about 4 or 5 records of the same thing. So what I did was I initiated a lawsuit against them, because what they did was if you study the Century Code, you'll see they broke 2 laws. Number one, every public record that you request is required to be immediately given to you. Not next week, not next year, not next month. And if they don't, then they violate the law, okay? The second thing is that when they unduly delay you, then the record is actually free. It turns from costing you something to free. Then the third thing is the fact that I asked specifically that the record be provided in electronic form, and they just did the opposite to make sure that it was costly. What they were hoping was I would show up there and they would say, "It's $300 and some odd." Then I would say, "Screw you, I'm not paying it." But I paid it, but I got it back, along with my filing fees, and along with the fact that every time I asked for a record again in the future, I got it. And by the way, if you read the Century Code, when they deny you a public record, that actually can turn to a criminal offense. I'm serious. And every time they deny you a public record, you can also use it as a method to punish them, not only criminally, but civilly. There are civil penalties in there for the denial of a public record. So the main thing that I want to tell people is, whoever said this one, whoever gave this statement, it is a duty of every American to know and to understand the law. Who said that? Anybody? Abraham Lincoln, a self-taught, an autodidactic lawyer from Illinois. And he said that, and that's, if you really think about it, that evolved eventually to ignorance of the law is no excuse. But that means the same thing. You have to know the law. Otherwise, you could become a victim to it as well. And that happens all the time. So anyway, I'm putting together a website, and it's called Self-Help Legal Per Se. And what we're doing is we're putting together a website, and eventually I'll give you out some information on that. And we're just starting it right now, but what we want to do is we want to go into all different aspects of self-representation. Because every time that you get a lawyer, you're giving up a power of attorney. It's called Self-Help Legal Pro Se.com. And the other thing that I wanted to point out is one other quote from a legal quote that people have never heard before, is every time that you use a lawyer, you are basically giving, or you're essentially giving power of attorney to somebody else. So you lose your voice. Your voice is no longer there. And the Supreme Court one time said in a case, they said that the only person in this country that can be assured of obtaining all of their rights is a person that is a belligerent claimant in person. Think about those words. You have to be belligerent, you have to be a claimant, and you can't be represented by somebody else. You have to represent yourself. Now, I'm not saying that I've never used a lawyer. I work for one. But frankly speaking, the only times that I've ever lost in any cases I've ever been involved with personally is with a lawyer. Every time I've been represented by an attorney, it's not worked out real well. Every time I've represented myself, pretty much most of the time I've won, or I've got at least at least I felt better when I walked out of the courtroom, because I didn't have the expense of the lawyer, and I didn't have the expense of losing, having both of those things at the same time. And frankly speaking, if you're not educated enough, you will be a victim either to the law or to a lawyer. Because just like medical issues, you have to take personal responsibility for your own particular health situation. Well, your legal health, you have to take personal responsibility for that. Any questions?
Talking about your subject right now is actually a case I believe is in Belfield right now, where somebody requested financial information from the city.
Is that guy this guy?
No.
They actually put
Mary's
What's his
on there.
name?
It's, is it on there? No. Here, this is his name.
Okay.
Ted Keller.
That's him.
That's
Okay.
public records. They requested something, and they said the amount of documentation that is gonna be required to give it, they wanna charge them $8,000. And if they can't get it done in a certain amount of time, they wanna charge them like $45 an hour on top of that. to Finish together.
How did they come up with the $8,000?
That I'm not sure of.
Well, they can charge if a record is say buried someplace like in the archives of a county or something like that. They can charge you a reasonable fee to go and obtain it. But what kind of county or what kind of city or what kind of government doesn't know where their records are? That's a ridiculous argument.